Thank you all for joining us this evening at the Manhattan Institute's annual Hayek Lecture. The world needs to know more about freedom, which is why we created the Hayek Lecture at the Manhattan Institute in the first place. Friedrich Hayek and the Manhattan Institute have an intimate connection going back to the days of the British entrepreneur and philanthropist Sir Anthony Fisher. Fisher helped found MI in order to advance the ideas of market philosophers, including Hayek, whom he knew. Indeed, he founded the Manhattan Institute and many other think tanks, such as the Atlas Network and the Pacific Research Institute, at the advice of Hayek himself. So it makes sense for us to be doing this work now and in the future. That the Hayek Prize ranks among the world's most generous book prizes is a testament to how seriously we take the job of advancing the principles of liberty, economic choice, and decentralized planning. For years, the Hayek Prize has had two essential tasks: to demonstrate the universality of Hayek, but also to honor the scholarship on Hayek's work. This year, the Manhattan Institute has chosen to separate the two criteria and to award a second additional prize focused solely on Hayekian scholarship. This year, that prize went to Bruce Caldwell, a professor of political economy at Duke University and the author of Hayek's Challenge, an intellectual biography of Friedrich Hayek. He's also the general editor of the collected works of Hayek. We think there is no scholar that was more fitting than Bruce to inaugurate this prize, and we had a luncheon for him today to discuss his work. So we're very pleased that we're able to add that additional award this year. Before we begin the lecture for the big prize, we created a short video that summarizes the many outstanding finalists for our prize committee that was considered this year, and I hope you enjoy it. Thank you.
The purpose of the Hayek is not just to give an award, it's to highlight a problem. What is the big theme this year? And it's the administrative state, it's bureaucracy, and it's encroachments. There's the government you vote for, but then there's the government that's there regardless. You have no choice. The problem started in the first progressive era, in the time of Woodrow Wilson, and then in the New Deal of Franklin Roosevelt. First one bureaucracy, then two, then 20, then 50. They're like boulders in our path, and yet we cannot question them or unelect them. Hayek wrote in The Road to Serfdom, a boss might be a burden upon an employee, but far greater than any boss or any millionaire was the bureaucrat. In the progressive era, the idea was we should put the smart people in charge. Hayek got at that smarter is not always better.
One of the dominant ideas is the idea that we can design social institutions in their working. Social institutions have never been designed and do much more than we knew.
Knowledge comes from strange sources, it grows organically, and even the smartest of the smart cannot always anticipate the best solution. Which books talk about this? Which books show how it might be better? Which books challenge the administrative state? Philip Howard's The Rule of Nobody is the book that explains why administration is objectionable. When rules take over, people are second. And he works very, very hard to capture the absurdity of our everyday life and says, you don't just have to live with this, you have to identify it and then begin to object to it. How has our liberal freedom been lost? Epstein traces that loss case by case. If you want to know how it happened, Epstein is your Bible. Sometimes we think about bureaucracy, there is no alternative. What Stringham shows is that within the United States, all the time, little examples of private governance are functioning, are beautiful. What Cesar Hidalgo shows in this book, and so brilliantly, is that information grows by itself. Bureaucrats, in fact, get in the way. Ideas spread by themselves. This is what we know intuitively, but Hidalgo traces it with a fine line. It's a joy to read this book. The logic of the market uses Hayek's philosophy to examine China. It shows that where the growth is just political, that's not real growth. And thereby reminds us, as Hayek did, that Administrators aren't the answer, innovators are. The jury thought about it, and we chose Philip Hamburger and his book, Is Administrative Law Unlawful? With his axe, Hamburger whacks the original root of the big tree of administration. It's not part of our Constitution, and he makes that case with the incredible authority of a strong law professor, and we've been lacking that book. Here it is.
I think administrative power is the civil liberties issue of our era. One of the most fundamental aspects of our liberty is that we have our laws made by representatives and thereby with consent. But there is this government within the government, an administrative state, that is largely unaffected by elections, that exercises power over us through its own system of legislation and its own court system. That movement against administrative power is going to be a tough battle. So I'm most grateful for the Hayek Prize because it will help get the word out.
A figure like Philip Hamburger is really necessary. Young law professors need to follow him. This prize says you're not alone if you think freedom is important. Welcome to our community of courage. You belong with us. We think we can make some progress.
And now we're honored to have John Tierney here tonight to introduce this year's Hayek Book Prize winner, Philip Hamburger. John is a long-time New York Times columnist where he has written about science, politics, urban affairs, and other topics. Most recently, and happily for us at the Manhattan Institute, John joined City Journal as a contributing editor, and we're really delighted to have him. Please join me in welcoming John Tierney.
Thank you very much, Larry. Tonight, we're honoring a book that could not be more timely or important. Administrative law may sound remote and abstract, but that's only until you see the harm resulting from its abuse. Our country's founders fought a war, and they wrote a constitution to stop this abuse. Yet today, it threatens us more than ever before. I'll give you just one example. In 2010, an assistant secretary at the Federal Department of Education heard a radio report about a purported crisis. The report was produced jointly by NPR and by a group named, rather misleadingly, the Center for Public Integrity. The report claimed that there was an epidemic of sexual assault on campus that was being cavalierly ignored by school administrators, by police, by federal officials. It was a textbook example of journalism that doesn't let the facts get in the way of the story. It offered absurdly inflated statistics, junk science at its worst, along with an alleged horror story from one school that was later soundly debunked. But by then it didn't matter. That one unelected and misinformed functionary at the Department of Education was so moved by that report that she single-handedly stripped the rights of millions of college students. She didn't bother consulting with Congress. She didn't even bother following her own agency's policy of giving the public a chance to comment on proposed regulations. Citing Title IX, a law that had never been intended for this, she simply wrote a letter to colleagues, and it was called Dear Colleagues, this infamous letter, ordering colleges to start hearing sexual assault cases in special courts designed according to her rules. Rules that, as the Harvard Law faculty said, lacked the most basic elements of fairness and due process. The result has been dozens of lawsuits against colleges and countless genuine horror stories by students whose lives have been ruined in these new versions of the Star Chamber. Now, that bureaucrat's letter is considered the law of the land, but is it actually lawful? That's the question brilliantly addressed by tonight's winner of the Hayek Prize. Philip Hamburger is a superb scholar of constitutional law and history. He's the Maurice and Hilda Friedman Professor of Law at Columbia, and he is the author of 2 previous books, Separation of Church and State and Law and Judicial Duty. Tonight we honor his latest book, his Administrative Law Unlawful, that is a sweeping historical analysis showing how today's edicts from Washington are remarkably similar to decrees from English kings who asserted that they had a prerogative to act unilaterally. Their subjects beg to differ. And these decrees were gradually curtailed by English constitutional law and then later by the United States Constitution. Now, but since the Progressive era, as Amity said, and especially during the current administration, we have seen more and more officials in Washington who are reasserting that royal prerogative to act on their own. And Dr. Hamburger brilliantly demonstrates this in his book. His achievement is summarized by Gary Lawson of the Boston University School of Law, who writes, "With characteristic erudition, Philip Hamburger shows how virtually every aspect of the modern administrative state undermines the Anglo-American legal tradition and the ideas that the American Revolution was trying to reject." Now, these ideas were also rejected by Hayek, who warned of what he called the fatal conceit, the delusion by kings and other central planners that they possessed all the knowledge necessary to rule their subjects. Giving them unrestrained power, Hayek realized, was the road back to serfdom. So it is especially fitting tonight that we honor with the Hayek Prize someone, a scholar, who has a very different road ahead. Ladies and gentlemen, Dr. Philip Hamburger.
I want to begin by expressing my gratitude. I'm deeply moved by this prize. It is personally satisfying, but it also is more broadly important because it will draw attention to the danger from administrative power. Incidentally, this prize is especially meaningful for me because my parents knew Hayek. My father did his PhD under Hayek at Chicago, and my mother, who was Ronald Coase's research assistant in England, knew the Hayeks there. But I'll spare you the stories. My thesis is that administrative power is unconstitutional. Indeed, it is the central civil liberties question of our time. Many people understand there's a problem, but few understand just how serious it is. Administrative power returns to absolute power, to the very power constitutional law developed in order to prohibit. It thus returns to a pre-constitutional mode of governance. Many folks fear that conservatives are originalists who will seek a return to the past, back to 1789. But my argument is that we already have returned to the past. Not to this constitutionalism of 1789, but actually more to about the absolutism of, say, 1610. Administrative power thus restores the central constitutional danger that constitutional law was designed to defeat. And once this is understood, it becomes clear that administrative power is utterly unconstitutional. In sum, this is a legal argument. Although we still have the shell of a republic, administrative power creates within it the very sort of government, absolutism, that constitutional law was expected to prevent. As an introductory matter, I should explain what sets my argument apart, what makes it different from the usual economic critiques of administrative power. During the past century, most complaints about administrative power have been from an economic perspective. These are the complaints that administrative power is inefficient, that it is dangerously centralized, that it produces too much regulation, that it's too burdensome, that it stifles innovation and growth. And all of this is true, painfully true. But these are economic complaints, and economic complaints cannot be the entire critique of administrative power. They are not apt to persuade persons who do not understand economics, and they're not apt to persuade judges whose training and duty is to focus on the law. Indeed, the economic complaint tends to accept administrative regulation that is not especially burdensome, and it thereby often accepts the legitimacy of administrative power and merely protests its extent. The economic critique, therefore, has not stopped the growth of administrative power. On the contrary, administrative power has expanded with each decade. So we have to reconsider the critique, or at least add to it. And it therefore is essential to pay attention to another sort of argument, one based not on economic costs, but on law. It is true, much administrative power is economically inefficient. There's no doubt about that. But all of it is unconstitutional. Indeed, it is a gross violation of constitutional law, a profound threat to constitutional rights, and one of the greatest threats to civil liberties in the nation's history. This is a much more complete and more legally effective argument, and I'm glad to say it is beginning to gain traction among lawyers and judges across the nation. This talk comes in three parts. First, I want to give some examples of absolute power, both then and now. Second, what do I mean by absolute power? And then third, how does the US Constitution reject this sort of power? First, let's look at some examples of absolute power then and now. Part of my argument is that administrative power revives absolutism. To illustrate the revival of absolute power, let's look at some examples in the past and then the present. And let's begin, of course, with James I. Of course, James. He was an academic, so no wonder, right? He was King of England from 1603 to 1625. And unfortunately for the English, he openly exercised absolute power. He was not content with the government's power, its regular power to make statutes in Parliament or to have cases adjudicated in the courts. No, that's not good enough for James. In addition, he wanted to exercise extra legal versions of these powers in his prerogative or administrative agencies. And this extra legal power in his agencies is what we call administrative power. It's what they called absolute power. His prerogative over administrative agencies most famously included the Star Chamber and the High Commission. These bodies are often associated with blood-soaked torture chambers, as if all they did was, use the rack, the thumbscrew, and the rest. But in fact, they were more bureaucratic than bloody. Rarely did they use torture. Mostly, they just used bureaucracy. They were efficient administrative agencies that commissioned expert reports and then made and enforced administrative regulations. Sounds familiar? Instead of legislating through acts of Parliament, James used the Star Chamber to issue binding proclamations or regulations on trade, manufacturing, and urban development. But the judges in 1610 declared such proclamations unlawful and void. Unlike today, the judges recognized that lawmaking outside of the legislature was unlawful. James also used the Star Chamber and High Commission to evade the courts, to substitute administrative process for the due process of law. And when his prerogative or administrative agencies interpreted statutes, he demanded judicial deference to their interpretations. But the judges again understood better. They generally refused to defer. Chief Justice Cook in 1608 told James that he lacked judicial office, and the judges had the office of judging or interpreting. The judges, therefore, could not defer to the interpretations of his administrative or prerogative agencies. In other words, no Chevron deference for James. In such ways, James used his agencies to exercise what then was called absolute power, and the judges, at least sometimes, condemned it as unlawful. Now, let's look at some contemporary examples. Sadly, the problem comes from presidents and other politicians, as well as kings, and indeed from both parties. It's hard to blame either party. Each almost competes sometimes to be more abusive in their use of administrative power. Like James, they want to govern us not by statutes made by the legislature, but by administrative rules and interpretations, and not through judgments made in courts, but through administrative adjudication. An example of administrative lawmaking can be found in the Affordable Care Act, which expressly authorizes Health and Human Services to make rules on health care. Other examples of administrative lawmaking can be found in almost all federal agencies. There are literally hundreds of agencies that do this, that make law outside of Congress. An example of administrative interpretation is the Clean Power Plan. This is an EPA rule designed to reduce greenhouse gas emissions by establishing emissions standards for existing power plants. Most commentators protest its substance, and rightly so. But what I want to focus on is the method of making the rule. The EPA claims authority to make this rule on the theory that it is merely interpreting an obscure section of the Clean Air Act, and that courts must defer to its interpretation, Section 111D, if you really care. This is what's known as Chevron deference, named after a 1984 case, Chevron versus National Resources Defense Council. And it dangerously empowers agencies, because wherever Congress doesn't speak, the agency can simply say it's interpreting and thereby creates law. Another example of this administrative interpretation is the EPA rule on waters of the United States, an EPA rule that ambitiously controls almost all waters in the nation, perhaps even the moisture on your forehead. Really. Anything that's damp is potentially covered by this. Yet another example is the Department of Education's interpretation of Title IX, which was mentioned, the Dear Colleague letters, in which the department uses this interpretation to control speech on campuses. Finally, there's administrative adjudication, and this can be illustrated most beautifully by the Securities Exchange Commission. The SEC can refer insider trading cases to the Justice Department for it to prosecute criminally in federal courts, where defendants get judges and juries and the full constitutional range of procedural rights. But the SEC can also pursue such cases administratively before administrative law judges, who work for the SEC, who are not judges, who do not offer juries, who give only a fraction of the due process required in courts. I call this not due process, but faux process. All of this is administrative lawmaking, interpretation, and adjudication, and it constitutes the new absolute power. Rather than be confined merely by Congress and the courts, Americans nowadays are also restricted or ruled by administrative agencies. Okay, now let's shift gears. Let's move from examples to a conceptual inquiry. The second part of this talk asks simply, what is absolute power? The phrase absolute power is often used as a term of abuse, but it traditionally had very specific meanings. And one of these is especially important for us in understanding administrative power. For our purposes, the key point is that absolute power was extra-legal power, in that it bound not through law, but through other pathways or other mechanisms. Anglo-American law traditionally established clear avenues for binding persons. You had to either have an act of the legislature or an act of a court, otherwise there's no legal obligation. These were the only ways of creating legal obligation. Nonetheless, absolute power bound persons through other paths, and in this sense, absolute power was extra-legal. Kings, for example, bound the English not merely through statutes, but through their proclamations and their bureaucracies, regulations, interpretations, and adjudications. And presidents and their bureaucracy now do the same thing again. Now note, in saying that absolute power was extra-legal, I do not mean simply was unlawful or is unlawful or contrary to law. That doesn't even begin to capture it. Rather, it's extra-legal in the sense that it binds or obliges people through means other than law. Put another way, in simple terms, administrative power or absolute power evades the regular avenues of power. Third, and finally, administrative power is unconstitutional. Now, how does the US Constitution bar administrative power? It doesn't have that administrative power section that says, no, don't do that. It doesn't have that section. But it does have some sections that are very revealing. First, the Constitution establishes only regular avenues of power and thereby blocks extra-legal or administrative power. The Constitution rejects extra-legal lawmaking by placing legislative power in Congress, and it rejects extra-legal adjudication by placing judicial power in the courts. Second, the Constitution protects procedural rights to bar administrative or other extra-legal adjudication. Most of the Bill of Rights actually is not substantive. Most of the Bill of Rights consists of procedural rights. And it protects such rights not only to set standards for the courts, but also to preclude alternative modes of adjudication. So, for example, due process of law is not merely a standard for the courts. It's a bar against administrative power. Jury rights are not merely a standard for the courts, but an obstacle to administrative power. In fact, almost all procedural rights were designed as barriers to administrative power. The Supreme Court obviously has forgotten some of this, but that just makes it all the more our duty to remind them. Third, administrative lawmaking is justified as delegated power. But this delegation is actually expressly barred by the Constitution. Cass Sunstein, a former colleague of mine, asks, where is delegation barred by the text? Now, whether he really cares about the text is an interesting question, but we can leave that for another day. If one really cares about the text, one actually need to look no further than the very first substantive word of the Constitution. The very first substantive word, all. All legislative powers herein granted should be vested in a Congress. If all legislative powers are in Congress, they can't be elsewhere. If the grant were merely permissive, not exclusive, there would be no reason for the word all. The word all bars delegation. Fourth, the necessary and proper clause bars the rearrangement of government powers. The necessary and proper clause authorizes Congress to do what is necessary and proper to carry out the government's other powers. And it therefore is usually thought to allow Congress to create administrative power, to do a little rearrangement. But this assumes that the clause authorizes Congress to do what is necessary and proper to carry out the legislative and judicial powers in the abstract. In fact, the clause authorizes Congress to carry out the government's other powers only as they are vested by the Constitution in particular departments and persons. The necessary and proper clause thus carefully avoids authorizing any rearrangement of powers. Fifth, Chevron deference is systematic bias. By the way, this is not the way I teach, because if I were teaching, I'd ask you to answer the questions. This is the way I do exam review, actually. And afterwards, we'll distribute some questions. So Chevron deference is systematic bias. Chevron's a case that requires judges to defer to an agency's interpretation of its authorizing statute. This is the source of much of the worst of administrative power, including the Title IX fiasco. But where the government is a party to a case, Chevron pre-commits the judges to the government's legal position. This is something that no one's noticed in something like 30 or 40 years. But think about it. Where the judges commit themselves to deferring to an agency's interpretation, what they're saying is we're favoring the government's legal position. This is systematic bias. It's barred by the canons of judicial ethics. Judges need to recuse themselves whenever they're about to do this. What's more, it violates the Fifth Amendment's due process of law. In fact, it's hard to think of a greater violation of the due process of law. Sixth, administrative power is not necessary. Necessity has always been the leading justification for absolute or administrative power. But is it really necessary? Well, that's an empirical question. And thus far, there's no scientifically serious empirical evidence of the necessity. None. We've had administrative power for over 100 years, and we have yet to see the empirical proof. The evidence that administrative power is necessary should be relevant textured. That is, the evidence that it's necessary in, let's say, 1890 does not show that it's necessary today. In fact, the evidence that it was necessary in 1990 is not very relevant today because we now have the web and people can protect themselves by just reading. The evidence of the need to license one drug or industry is not evidence of the need to license all drugs or industries, and so forth. Those who depart from the Constitution on theory of necessity have the burden of proving the necessity. Seventh, one version of the necessity argument is that administrative power is a modern response to the complexities of modern society. Maybe, but that's puzzling because, administrative power isn't modern. It revives absolute power. Rulers have always tried to evade ruling through the law and the courts, and whether you call it prerogative or administrative, it's an ancient familiar threat. It's not so much a response to modernity as a symptom of lust for power. To say administrative power is modern is a little bit like saying monarchy is contemporary. Perhaps it is, but I want to fight that. 8, a final philosophical point. We need to focus on the principle of rule through law rather than rule of law. Rule of law is nearly meaningless. It can mean anything authorized by law or even merely law-like commands. By that standard, all administrative law really is law and we should just submit. The Constitution's principle is rule through law and through the courts of law. Rule of law is thus just a distraction, and we must demand rule through law. In conclusion, at stake is nothing less than the 1,000-year common law effort to establish governance through and under law. In a brief century, administrative power has revived absolutism. It has restored a pre-constitutional, extra-legal mode of governance. This is justified as a modern, pragmatic response to modernity, but in fact, it is the recurring danger of absolutism. Thank you.
Dr. Hamburger would be glad to take some questions. I just want to ask one quick one to start. Isn't the fact that there's been such growth in administrative law and the fact that the government is working so well today, isn't that just evidence for its efficacy? Yes. I mean, those of us who've been in line at the TSA, I think, would have to disagree with you.
Yeah, more and more is better. It's like ice cream. You just can't get enough. It's actually interesting to listen to some of my colleagues who I would generally identify as liberal or left, describing administrative power precisely along these lines. They say, we have so much of it. It must have been adopted for a reason. It must be good. And then when you point out to them that you cannot think of a more conservative, indeed retrograde mode of arguing, that in fact you're just defending the status quo, they pause because they realize that in fact that's not how they identify it. So yes, that's right. We should press this point.
Michael here.
Thank you for the talk. Michael Myers, President, New York Civil Rights Coalition. Article 3, how can administrative power be unconstitutional if the United States Supreme Court doesn't say so? That's what the Supreme Court determines whether it's constitutional or not. Article 2, with respect to the the presidential power, the president enforces the law. That includes interpretation. How can administrative power be absolute when we know that Congress can override an administrative action just by acting, making a new law or reversing administrative action? That was Article 1, I'm sorry. Article 2 was Article 1 would be the Congress having the power to correct as opposed to accept absolutely.
Thank you. I hadn't thought of you as a legal realist. It's an interesting problem, isn't it? Our institutions, Congress and the Supreme Court and the presidency, all three branches of government, have served this up to us and told us it's lawful. And in those circumstances, what hope is there of pushing back? One might just say, give up and accept it. But if I were being mugged, I don't think I would just give up and accept it. I don't think anyone in this room would do that. And nothing's forever. We're told that this is somehow as solid as this table and it cannot be moved. But everything can be moved. So I'm not that worried. The Supreme Court, in fact, I think is already rather worried. The Supreme Court, for example, gives us the Chevron deference on the assumption that somehow the judicial power can be shifted from where Article 3 places it into the place where Congress has put it. But actually, beginning 2 years ago, I'm glad to say, in response to my arguments, they have doubts. They've now hesitated to apply Chevron deference in the last year and a half. I think that's very encouraging. In other words, it's a great mistake to give up. Just because Congress wants to give away the power the Constitution places in Congress doesn't mean Congress can't be reformed. But personally, my path will be through the courts. And I'm hoping to actually form an organization to litigate, to persuade the courts to back off. And I'm actually more optimistic than you may think. Thank you.
Yeah, thanks for your inspiring talk. Please elaborate on what you just said. I noticed, for example, that your book is very respectfully referenced in Charles Murray's book, in which he's got a big plan. I gather you're somewhat critical of his plan, although you guys are obviously on the same team. But what is your plan of action? I gather you have one. Tell us all about it.
Okay. I have great respect for Charles Murray. I know he's much smarter than I am, amongst other things. But I think his plan was not thought out from a lawyer's point of view. His plan was to spend $100 million, which I don't have, to defend everybody hurt by administrative power, which would cost a lot more than $100 million, and I think would be a losing proposition. I think instead one has to be a little more agile. What one needs are to look for the chinks in the wall, the places you can crowbar in to loosen up a brick and then another brick and so forth. And the weak points, and I think it's very important not to litigate as has been in the past, which is defensively and very political cases. Instead, one has to look for the types of power that you can take down and thereby cripple administrative law across many agencies. And so the key is to look for the weak points where you can get to certain types of administrative power. Now, where are those? It's no secret, I generally don't like to talk about litigation strategy in public, but it's no secret what my views are about the first step. One of the first steps is Chevron deference, which is why I've been fighting that. It's really Chevron bias, as I explain in an article. And that should make the judges nervous. The judges are a weak point in the system because they care about their integrity. They care about their judicial independence. They don't like being told that they're biased. And in this instance, there's really no response they can give. Now, I don't want to actually litigate this. What I'd like, rather, is to have the judges just become worried that they might be asked to recuse themselves. One has to be delicate and respectful of their sensibilities. They're serious people doing serious work, but I want them to reconsider, and I think one can get them to reconsider on all administrative bias. So that's a first step right there. A second step, I think, seems to me, is to litigate on free speech issues. The judges are pretty good in free speech, and a lot of administrative power these days is used to control speech. For example, my speech, if I were to ask one of you a question without getting prior permission from a censorship board, I will be fired. It makes McCarthyism look like small potatoes. That's courtesy of HHS, which views speech as a health threat. So that, I think, is begging for litigation. I can't wait. And that will be particularly delicious because, in fact, that sort of censorship is used to control science throughout this country. We think we have a lot of scientific freedom. We don't. My interest in this began when I was sitting around at a friend's house, and he said he couldn't publish a statistical article, and she, a distinguished scientist, couldn't actually look at the tissue banks to save the lives of children because there was just too much bureaucracy. These censorship boards are stifling science. We'll all live 10 years longer if we kill off these boards. So medicine will be freed if we do this. So those are the first steps. And I could go on, but I think you get the idea. There are weak points, and one should go for the weak points. I like General Patton's idea of warfare.
Well, thank you very much for those most inspirational remarks. I have a couple of quick questions. First of all, Congress, for example, with the Department of Labor, said that it expressly delegated the authority to say when white-collar workers have to be paid overtime. The Department of Labor has just doubled that ceiling to $47,000, so white-collar workers paid under that have to be paid overtime and keep track of their hours. But lawyers don't see how they can fight that because Congress expressly told the Labor Department to do that. So how would you treat that? And second, with the Dear Colleague letter from the Office of Civil Rights, if it's a guidance letter, is it legally binding anyway? It didn't go through the regulatory process. It didn't get comments. So is it really legally binding the way a regulation is?
Right. Those are very interesting questions. So first of all, on expressly authorized rules, first example you gave, that's the last thing I want to litigate. I think one has to build up to that. And I wouldn't want to litigate that case. I'd want to litigate a very apolitical case. But you're absolutely right, that's the core. But that core has to be approached carefully. One wants to work step by step. So the order in which one does things really matters. And then as to guidance, right, it's really rather odd. Government by raised eyebrow is the phrase that I've heard in respect to this. The government actually doesn't have to tell you what they want. They just have to make you fear. At least with the guidance, they tell you. Sometimes they don't even tell you. This is very dangerous stuff. And the question then is how to approach it. I think if one cannot, one of the beauties of attacking Chevron deference first is it clearly involves deference by the judges. They proclaimed this, and it makes them look awfully biased. Once Chevron deference falls, then you move on to our deference, which is deference to agency interpretations of regulations, and then one moves to the guidance. Because if we can kill off the more formal forms of deference to agency positions, then I think guidance follows, right, sort of inevitably. It's very hard to litigate on the guidance issues for a host of technical reasons, which is why I think one has to begin with the other cases. But yes, it's very dangerous, very, very dangerous stuff.
Thank you. Is expansion of administrative power a problem at the state level as well? And how are the states responding to the federal government's expansion of administrative power?
Yes. This is a source of both despair and amusement for me. Yes, the states are awful, some of them, just awful. And some are particularly awful. Virginia, you would have thought Virginia, which has 2 separation of powers clauses in its constitution since 1776 would be a good state, but no, they added a special administrative power amendment which authorizes all administrative power. So the states can be just as bad, if not worse. So what I've been talking about is mostly federal power because it's cleaner there. And so, right. So that's the hope. It seems to me the states are going to be a source of great inspiration. The states have some remarkable lawyers, and one of the joys of the past year is been traveling around getting to know them. And some of the states are pushing back for federalism reasons, and these folks understand administrative power. They want to work against it, and this will be a very beautiful thing to watch. I don't want to go into detail, but it gives me great hope. These are remarkable lawyers, and they understand it, and they have an axe to grind because their states are being destroyed by federal administrative power. But just to give you a sense of how dangerous it is for them, the Supremacy Clause says that if you have an act of Congress, that will trump a state statute. Okay, fair enough, that's federalism. But now, an administrative interpretation trumps a state statute. And this grates rather harshly on the idea, on some of the states.
John Stossel.
In your ideal world, how would this work? People assume there are some things in the modern state that these agencies have done that they like. I can only think of maybe one. But the EPA, which you mentioned the extremes, but until it became what it is now, it got the air cleaner, it got sewage treatment plants built. How would this get done properly?
Right, and I assume you're not talking about the Colorado River or Flint. Yes, but take this seriously, you're absolutely right. There's a lot of regulation that's actually very useful. We don't always know which the useful regulation will be, but undoubtedly some regulation is very, very valuable. So the question is really not what regulation, but how it's adopted, right? Now, who would do this? I don't think we really need the EPA, but we don't need to abolish it. The EPA could simply study the matter, and with all their expertise, which I actually think is dubious, but if they had the expertise, they could give advice to Congress, and Congress could simply enact regulations proposed by the EPA. We do not have to abolish a single agency to get to where I want to get. All we have to do is to have the laws enacted by Congress and adjudications happen in courts. So to just give another example, the FDA can advise Congress on which drugs need to be licensed, and Congress can do it. Congress can do it very quick, in fact, much faster than the agencies can do it, if it wants to. The obstacles are political, not technical.
I'm interested to hear how you think Judge Merrick Garland, nominee to the Supreme Court, fits into all this.
So I don't like making predictions, especially about the future. I don't know. I haven't studied his record. I've glanced at it. I've seen some hints that he is perhaps sympathetic to administrative power, but I think it would be premature to say, because when people undertake the judicial role, sometimes they change. Now he's moving from one judicial role to another, but I don't really know. And I'll waste my time studying judges once they actually get to the place where I have to worry about them.
Hi. There's something that is...
Can I just add to that? There's something more important, more serious answer. As I reflect, that's not a serious enough answer. The real reason I don't know is I'm interested in legal ideas, not people. I love people, the people I know, but ultimately, academically, it's not people that interest me. I'm interested in ideas and the damage they do, and ideas that can counter those. So I spend my time studying the ideas, and this actually gets to the sort of litigation I want to do. I want to litigate against ideas of power, not merely against particular programs or against particular administrative officers. So there's a reason why I haven't focused on Mr. Garland. Sorry.
There's something a little puzzling about this evolution of the administrative state, which is that we always believe that politicians want to hoard power. And yet in this, what you describe is Congress effectively deferring all its power to someone else, which would seem to run contrary to, what Congress would want to do, which is to hoard its power. How do you explain that? And the kind of related question is, what do you think about Congress now that you have, for example, Republicans, objecting to a lot of these administrative laws that the Obama administration is making? What do you think about using the power of the purse to roll this back?
Right. So you're absolutely right. There's a puzzle here, and many academics have studied it, not necessarily very conclusively. It would seem that legislators are quite content to raise money from their constituents, but are not terribly interested in exercising the power except when it really matters to them. They are happy to say yes. They want someone else to say no. So they shift the no saying off to the agencies. It's really it can be explained, I think, in terms of their individual interests in getting reelected and in reserving the decisions they want to make for themselves and leaving others to other people. The problem is an old one. Kings, both on the continent and England, used to buy off legislators. And there's an interesting question as to whether something like that has happened. Very, very transnational corporations at the really large level can really get quite cozy with agencies. And there's a great danger that although we think Congress controls the agency and the agency then controls the big bad corporations, maybe the opposite's happening. Maybe corporations influence agencies and agencies control congressmen. Certainly an agency making a decision about a host of different issues can determine whether or not many congressmen get reelected. So there's interesting stuff going on there that I don't fully understand, but I worry about. There was a final point to the question I missed. Oh, yes. So traditionally, the power of the purse would be an excellent way of dealing with this. Why whine about whether or not the IRS is turning over this message or that or the State Department? Just cut a little bit of funding. You just don't have to cut it all. Just take out $100 million there, $100 million there. You'll get people's attention. Or just trim all bonuses for the year. You'll get attention then. So it seems to me that's an excellent way of doing this. I have no confidence in Congress, however. And I don't think that Congress necessarily is like that, but with the administrative state, I have no confidence in them, which is why I think litigation is the best path.
Thank you. Was the establishment of the FIFA court a gesture that worked against the sort of a rise of more administrative powers around the problems that the court is now addressing in government and in regard to terrorism?
Right, so there's an interesting question about the boundaries of my argument. So the argument I've been making is about the domestic use of law to create legal obligation. And that argument stops at the border. So for example, as I explained in my book, licensing, I think unconstitutional domestically on the whole, is lawful as to things that move across borders, airplanes, pilots, and the like, steamboats in the 19th century. And then you get to the question of the role of this court. To the degree that it is controlling people subject to American law, I think my argument applies. And then we get to the interesting question of what is the nature, for example, of these warrants that are sent that have to be kept secret by the recipients, right, to essentially to dig out information about their customers. This is very problematic, right? Warrants should be issued by judges, real judges, and ultimately I think that means generalist judges. And warrants are not secret documents. If they are secret, then we have no way of dealing with the civil liberties issues there. So there's a larger question here that I care very much about, which is how do we handle the national security issues? This is complicated. I don't think the answer is simply going to be by saying administrative power is necessarily a good thing and we should just follow it come hell or high water. But there are areas where administrative power is being used, and one doesn't want to conclude that there's no power of the government to deal with these problems. I think there are other solutions to these issues. Let me give, the warrant issue is very complicated, so let me give just a very simple example of how I think we've misunderstood problems and there need not be as much of a problem as we fear. So for example, when you get searched at the airport, right, is this a case in which there should be a warrant? In which case, is this an unlawful intrusion on one's body and one's stuff? Many people would think so. I actually don't think that's the case. Because there's a whole legal category that's more or less been forgotten called inspections, which would be authorized by Congress and that are not unlawful. To the extent statute dictates the extent of the inspection, there's no legal problem there whatsoever. So I think in the case of the warrants regarding electronic information, one could turn to inspections or other such means of inquiry that do not leave such discretion in administrators. Because the danger is that an agency will really have great discretion in issuing one of these warrants, let's say to Verizon, and then the court will rubber stamp it. And that's what we need to avoid. It seems to me judges should be issuing warrants, but there are things government can lawfully do with the right of authorization, which they don't have. So I think this entire area of the law needs to be rewritten because it can be rendered lawful on the whole if done properly, but we've forgotten how to do so. It's a very serious problem.
One more question, and then we'll get to dinner. So,
well, first, thank you very much for a very inspiring speech. I have so many questions, but I'm going to limit them to one. Okay, I was going to say two, but okay. Being a big fan, as I am, of Hayek and the whole philosophy, the one question I would ask is, one of the things that disturbs me is every time I listen to the news, New York says, come to New York and we'll waive your taxes. Well, somebody else picks up their taxes. And New Jersey says, well, come to New Jersey and we'll waive even 11 years of taxes. So the Interstate Commerce Clause, obviously, is in the Constitution. Would you agree that there should be a law that says no state or subdivision thereof should subsidize their favorite people, whether it's small businesses owned by millionaires or companies that are in wind or in whatever so-called industries that the Democrats like, basically to say you can't do that, and you can only subsidize, as Hayek said, I'm a big fan of Hayek's, needy people. People who need help, but not anyone other than needy human beings, not small, rich businesses owned by rich people. Would you use the Interstate Commerce Clause?
Think tanks should be exempt, though, right?
One could do this, but maybe we already have a law that addresses the question, which hasn't been explored yet, namely the Equal Protection Clause of the 14th Amendment. That's not the current jurisprudence, so don't put too much hope into that. So perhaps your law should be adopted. Thank you.
Thank you very much, sir.